Welcome everyone. Today we're diving into a crucial topic which is known as stealing under section 383 of the criminal code. For example, if I take this person's phone with the purpose of not returning back to me, is that stealing? What does the law say?
According to section 383 of the criminal code, the law says that a person who fraudulently takes anything capable of being stolen or fraudulently converts to his own or to another person's, anything capable of being stolen is said to steal that thing.
She spoke about fraudulent intent being the backing for conversion. What is fraudulent intent? According to the section 383 subsection 2a to f, it describes the scenarios which may cause fraudulent intention. A, the intention to deprive the owner of his property, to deprive someone who has special property in the goods, to use it as pledge or security, to use it unsure of its return, and to use it in a way of damaging it as opposed to its original state. And when it comes to the case of money, to use it as your free will, even if you have the thoughts or the will to return it.
Of that same section provides that the taking or conversion may be fraudulent, even though it is effected without attempts of concealment or secrecy. And also it is immaterial if the person that converts it does it for the purpose of conversion or converts it from somebody that has converted it already.
Element of stealing. As seen in the case of Ogun versus the state, the court held that the first element of stealing is that the thing stolen must be capable of being stolen. The second is that the accused must have an intention of depriving the owner of the thing stolen permanently. The accused must be fraudulent or dishonest. The accused must have appropriated the thing stolen to his own personal use.
In the case of Ago-Iwoye versus the Queen, the appellant, who is the chairman of the district council, collected money from a particular company for his council. He then deposited the money in his personal account for his own use. He was then charged for stealing. According to section 228 of the criminal code, it states that when a person receives money on or behalf of another person and converts it for his own use, the person is said to have stolen that particular money or goods.
It has been an insightful session so far. However, must the owner of the stolen property be named while charging the suspect?
If the owner of the property is being known, it is best fit to add the name in the charge. This strengthens the case, clearly showing ownership and supporting the claim that it is being fraudulently taken. However, if the owner of the property is unknown, the law allows you to be described as belonging to persons unknown. This actually make the charge valid.
Talking about the exculpatory facts, according to section 383 subsection 5, when a thing conveyed has been lost by the owner and the finder converts it, the conversion is not deemed fraudulent if the person that converted the thing does not know the owner and believes on reasonable things that the owner cannot be found.
Wow, I've learned a lot so far. But same section, subsection 6, state that a person shall not be deemed to have taken a thing unless he moves it or causes it to move. In Wahabi and Dejobi against the state, the appellant stole 7 million naira from Trans International Bank and argued that the bank was not a juristic person. They relied on section 382 of the criminal code, which says that every inanimate thing that belongs to a person can be stolen. They argued that since the bank was not a person, therefore whatsoever is stolen is not actually stolen. The court ruled that the Transnational International Bank is a juristic person. Why? Because it is registered under the CAMA and National Stock Exchange. Therefore, whatever money was stolen they were held guilty for that money that was stolen.
There's so much knowledge in this room. However, stealing has been proven beyond reasonable doubt. It is important for the prosecution to establish the essential elements in that particular case. As we can see in the case of Ago-Iwoye versus State, the only evidence they had against him was that the things he had in his home were far above his income. The court held that they could not prove it beyond reasonable doubt, hence he was discharged and acquitted. Thank you.
Alright, from the case you just mentioned, the case of Ago-Iwoye versus the state, the law states that there is no law that states that a person should be convicted for stealing, just that what he has is more than his income. However, what is needed is the evidence of how he got these properties and the other job he was doing.
The criminal code
states that a person who steals anything that is capable of being stolen is guilty of felony and is liable, if no other punishment is provided, to 3 years imprisonment.
Well, that wraps up today's discussion on stealing under the criminal code. We've covered essential points such as definition of stealing, fraudulent intent, cases, and even the punishment. Great insights, everyone. Thank you for watching.